Hello blog readers, I'm Alex Karasik, an associate with Seyfarth Shaw. I'm here today with Jerry Maatman, an esteemed labor and employment attorney specializing in class actions. Today we're here to discuss an emerging issue in the class action landscape involving the Biometric Information Privacy Act. Jerry, tell us, what is the BIPA?
It's the first statute enacted by any state here in Illinois that controls the collection and dissemination of biometric information, things like fingerprints, retinal scans, anything involving the physical characteristics of a person that can be used to identify them. Since its passage by the state of Illinois, businesses have been rushing into this space and adapting this new technology to assist them in making the workplace more efficient or for their interactions with customers. And as one might anticipate, legal issues are springing up, and it's created an opportunity for the plaintiffs' class action bar to file lawsuits for alleged breaches of this law.
So what can employers do to prevent themselves from getting sued under the BIPA?
Well, Illinois was followed by Texas, and now in one form or another there are 7 states in the United States that regulate or hoist obligations upon employers. California, Illinois, as we mentioned, Maine, Missouri, New Hampshire, North Carolina, and Texas. And so employers operating in any of those jurisdictions need to take a look at those laws, establish protocols for the handling of biometric information, so that if they are called to task for their treatment or handling of the information, they'll have sound protocols and practices to demonstrate their good faith, their efforts to comply with the law, and to create defenses to these class action lawsuits that are being brought by plaintiffs' lawyers alleging breaches of the law.
So let's say you're a general counsel, and unfortunately on your desk this morning was a biometric technology lawsuit brought under a statute like the BIPA or similar state statute. What types of strategies would you use to defend against this type of class action?
Well, one of the issues involves pocketbook injury. Was someone's information compromised in a way that caused damage to them? So one of the first issues is standing, and the concepts of standing articulated by the U.S. Supreme Court earlier this year in its Spokio v. Robbins decision. And some of the cases will involve situations where the named plaintiff or the case theory is such that there'd be no viable cause of action. But data breaches and invasions of privacy are now things that are being sued over all the time. And so sound policies and procedures, and even changes to those policies and procedures, even midstream in a lawsuit, could moot out some of the requests made by plaintiffs' lawyers to secure injunctive relief under these laws. And so an explanation and a hard look at the case theory, efforts by the employer to comply with the law, and then some creative lawyering to be able to defend these cases. In Illinois, there's been a deluge of cases. I've kept track of them, probably 25 or more. We've defended successfully one of the first ones and been able to kick it out of court based on these insufficiencies in the case theories. But I think this is generation 1 of these sorts of cases, and more lawsuits are apt to be brought not only in Illinois but in other states that are rushing into the space and beginning to pass laws that regulate the use of the information.
Thank you, Jerry. And for loyal blog readers, please stay tuned, because we're going to be all over these lawsuits getting filed around the country as the biometric technology laws continue to develop and plaintiffs continue to bring suits under these theories.